Green.
14A District Court for County of Washtenaw, State of Michigan is now in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
And good morning.
Your Honor, I have a question. This is Attorney Tuttle.
Why are you interrupting me?
I apologize. I apologize for interrupting you. I'm just sitting in another court. I just had a quick question. That's all.
What is it?
Do you have Demetrius Sanders on your docket?
Okay, the best way to do that, counsel, would be to type that into the chat. I have about 100 files that are sitting ready to hear, and I'm not going to pour through them and find out if I've got your case. Court calls the case, People versus Tiffany Blaisdell.
Nimish Ganatra, First Assistant Prosecuting Attorney for the People.
We are ready in this matter, Your Honor. Lauren Brown, still Deputy Chief Public Defender, appearing with and on behalf of Ms. Blaisdell. I'll let you know if it changes, though.
It's okay. We're going to change the initials behind Feaster's name. You watch. Go ahead.
Ms. Blaisdell, could you state your name for the record?
Absolutely. Tiffany Ann Blaisdell.
Your Honor,
What are we doing?
today is the date and time set for the probable cause conference. Ms. Blaisdell has been offered a misdemeanor in this case. I'll let the prosecutor state that.
Well, Mr. Brown, I'm consulting with both of the deputies before making that final offer. And one of them has gotten back to me and is supportive of that. The other person is on vacation until March 27th. So I need to finish consulting before I can make a formal offer, but I think that's where we're headed.
Very well, I understand. Your Honor, that being the case, we'd like to be able to address the bond.
Okay, go ahead. Address bond, and then I'll give you a date.
All right. So Ms. Blaisdell is housed in the Washtenaw County Jail. She's there because she was late for a court date. She was also scheduled to be a witness against another individual who's currently at the county jail. She, having missed the date, well, she didn't miss it. She just logged on late, and she was issued a bench warrant. So we'd like to have her bond reinstated. She's been in jail for how long now, Ms. Blaisdell?
14 days today.
Okay. We'd like to have her bond reinstated. We believe this matter is going to be resolved and hopefully through misdemeanors. And so at this point, Ms. Blaisdell will return to all future court dates. She will, she knows what to do now to be on time. We've talked about the process she needs to go to in order to make sure she's logged on and ready. So we're asking that her original PR bond be reinstated and that she'll be allowed to be released from the jail today.
Did she turn herself in?
Ms. Blaisdell, how did you come to be in jail?
Well, with the new home I'm at, apparently some neighbors thought there was some suspicious activity because I was new to the neighborhood. So they called the Washtenaw County and I opened the door. I knew I had a warrant, but I allowed them in. I figured, okay, we'll go ahead and just take care of this and address it with the felony warrant. I advised them. And so that's how that all occurred. But just
So she didn't turn herself in. What I will do is motion for bond reduction is denied. Her bond will continue as is. I will, however, set the probable cause conference. Hopefully we can get the conversations that are needed. I'll set it for next week. March 30th, 2023, 9 a.m. Thank you.
Thank you.
Court calls the case. People versus Devin Julia Martinez.
Or will I bring for the people?
Joy Gaines, Senior Assistant Public Defender, representing Ms. Martinez. Ms. Martinez, would you state your name for the record?
Devin Julia Martinez.
Your Honor, we are, I'm sorry.
Go ahead.
Okay. We are requesting a referral to mental health court for Ms. Martinez. Ms. Willenbring and I finished that information this morning in terms of the referral. I did send it to Ms. Tang. I don't know if Your Honor had enough time.
I have it in front of me. If it gets sent to her, it's here. So I have it. I'll sign off on that. I will then adjourn the probable cause for a determination on that to April 13th, 2023, 9 a.m.
Why 13?
Pardon?
Could it be any closer to the 3rd, like the other hearing?
Okay. Ms. Martinez, we went through this yesterday, didn't we?
I don't know what you mean.
Where you were trying to set your own court dates?
No,
Somehow
I said-
and or another. So just listen. They have to do, they're doing the referral. I'm signing off on that. They are going to have to do an assessment to try to see if you can get into this programming. Okay?
I'm certain I will be able to. Is the thing. And I've just
Okay.
I've been here a month.
But others have to make the decision.
So Ms.
You're not making the decision. So you very well may get in. I will then, as I indicated to you on the other case that is before me, your attorney is trying to get that to match up then to this case when it is settled in that case. So quit trying to rush it, quit trying to set your own dates, and
I
just
wasn't
let
trying-
your attorneys do their job.
May I
I'm
break out
done.
with my-
Bond continued. She's done.
May I break out with my language?
I'll come see you, Ms. Martinez.
Court does call the case of the people versus Dion Bird.
Good morning, Your Honor. Ashley Lonnie for the people.
David Goldstein appearing on behalf of the defendant.
Mr. Goldstein,
Yes, Your Honor.
I heard you were supposed to be before Judge Washington and you came here to see me.
Yeah, I it's one of those things,
That's
Judge.
okay.
Hey, if Torshio Feaster can join the prosecutor's office, I can go to court.
Okay, all right. Okay, fair enough. You're right. It's just we're in upside down world. All right, what are we doing?
Okay.
Court calls the case, the people versus Narilia Intula.
Caitlin Kirby on behalf of the people.
Ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Intuala. Could you state your name for the record, please?
Noriland Twala.
Your Honor, today is the date and time set for the probable cause conference. My client is respectfully requesting this matter be set for preliminary examination. We'd also like to address the bond at the appropriate time.
This is going to be just an officer testimony. I'm going to set this for preliminary examination, March 28th, 2023, 9 a.m. And I'm going to put that before Judge Washington.
Thank you, Your Honor.
As to bond,
Your Honor, my client is respectfully requesting this matter that he be allowed a PR bond. He is employed press operator. It is a fine job. He'd like to be able to keep that job. He has a home in Ypsilanti from which he would return to all future court dates. He also has a 12-year-old daughter for whom he has joint custody, and he'd like to be able to take the pressure off the mother and be allowed to take care of his custodial duties with his daughter.
I would just say this. I think the defendant has had a failure to appear previously. I had amended his bond. Part of the problem is, though, that he was ordered to community corrections. He didn't report over to community corrections. There was a bond violation was sent on the 6th, or February 6th, regarding that. And he just didn't contact them at all on this matter, giving him numerous opportunities. In fact, on March 2nd, he came in. We had that violation, told the defendant he needed to report to community corrections, and that if he did not report to community corrections, told him that day that he had to report today to community corrections. Guess what? He didn't report. And so the bench warrant was issued and he was going to sit. I've given him its preliminary examination in 5 days. At this point, given
Hello?
the defendant's conduct through this, I am not changing his bond. His bond will continue as denied. He'll have his preliminary examination on the 28th. Bond continue.
What?
Thank you, Your Honor. Mr. Ronald, you need to, there you go. Thank you.
We got him.
All right.
Calls the case, People versus Daquan Delane.
Caitlin Kirby, on behalf of the people.
Ron Brown appearing on behalf of Daquan. He's on my phone, Your Honor, on his voicemail. Say your name. You gotta say it louder. Can you hear him, Judge?
No.
Say it again. You gotta say it loud.
Okay, I barely heard it. Yeah, okay.
I'm requesting an adjournment, Your Honor. He's got technical difficulty.
Any objection from the people?
No, Your Honor, and I did get the video in this matter, and I'm going to be sending it to Mr. Brown, so I have no objection. It's fine.
Mr. Brown, you're gonna work it out with him before the next time?
Yeah, I'll just bring him up to the office if you want to come up here.
Okay. All right. Just do it old school. All right, April 6th.
Can I get a little longer, Judge, if possible?
April 13th, 2023, 9 a.m.
Thank you. I'd ask
Fine.
Bob to continue.
Fine, continue.
Old school still works.
Yeah, I know. I know.
See you later.
You are
Daquan.
you're the master at that. Okay. Calls the case, People versus John Smith.
I spoke with Mr. Smith about obtaining a potential resolution, and I've also spoken with Ms. Willenbring, and I think we just need a little more time to hopefully come to a resolution in this matter. So I'd be asking for a brief adjournment.
April 6th, 2023, 9 a.m. Bond will continue at this time.
Your
Thank
Honor,
you.
can I address bond?
Of course, Mr. Elman.
Thank you, Your Honor. I apologize. I'll try to keep it brief, but Mr. Smith was picked up on a case in Wayne County where he did post bond, and they issued him a tether on release. And I would be asking for the same here. I believe that a tether would ensure that Mr. Smith would be able to come to court. He is employed, and he did miss his last court date in front of Your Honor because he was suffering from COVID. I know you've heard that excuse a million times. However, I think that a tether would ensure his continued participation in court moving forward.
Any response from the people?
Your Honor, I do see on X jail, it's still showing that he has a detainer out of Wayne County. He has a hold out of Detroit, and he has a $500 bond on a CCW out of Madison Heights. And this occurred while he was on HIDA probation, and he failed to appear previously. So I do have concerns based on those holds and his failure to appear that he will not reappear. And this is a CCW, and he has another CCW in a different county.
And I guess part of also my concern is when he didn't appear here, he didn't voluntarily turn himself in. I mean, he got picked up on something else and then got released on a tether out of that case. So motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor. I appreciate your time.
Court calls the case of the People versus Ashley Hines Walden, 2 cases.
I'm asking for an adjournment. She's going to retain counsel, she said.
Yeah,
Is that correct, ma'am?
Yeah, if I can just respectfully add, I had to bond out, and with my tether tuition, I kind of needed a 4-week adjournment if that's possible, just because these are serious allegations, and I just want to make sure I have proper counsel. And because the defenders, are defective.
That's fine. You can hire whoever you want. You got Mr. Brown, you got the public defender's office. You're not going to find any better around the state, but you go ahead and give it your best shot.
No, I'm retaining it.
No, you go. What'd you say?
I'm retaining counsel.
I know, but if you think that you're going to find better, go for it.
Well,
I don't think you will. Probable cause will be adjourned April 20th, 2023, 9 a.m. That's your only adjournment for these purposes. You understand that?
Yes, Your Honor. Thank you.
Here we go. Court does call the case of the people of the state of Michigan versus Isaiah Williams.
Good morning, Your Honor. Danielle Russo Bennett, Assistant Attorney General on behalf of the people.
Good morning, Your Honor. Danian Woodson on behalf of Mr. Williams.
Okay, to do this, Mr. Williams, can you state your name, please?
Isaac Vernon Williams II.
All right. I do have the forensic evaluation. Did everybody get a copy of that?
Yes, Your Honor.
Is there any additional information regarding the issue of competency?
Not from the people, Your Honor. We would stipulate that Dr. Jeffrey Wendt, if he was called to testify,
Yes, Your Honor.
he would be testifying consistent with his report that Mr. Williams is competent.
And defense stipulates to that as well, Your Honor. I have had an opportunity to talk to Mr. Williams after reviewing the report, and I do agree with its findings at this time.
All right. The court, upon reviewing that report, would find that the defendant is competent to stand trial. Specifically, the court would indicate that based upon that report, the defendant understands the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I would need an order regarding that filed with the court so that I can sign off, but I will sign off once we receive the order.
Okay.
Okay. So where do we need to go from here? We need to set for a preliminary examination, I'm sure.
In Your Honor, I apologize. I didn't mean to cut Ms. Woodson off. I do need, we had talked briefly via email whether it was going to be a waiver or a hold. I think he is going to hold. It is probably going to be a lengthy exam, Your Honor. So it might have to be done in parts because I'm sure the court cannot dedicate an entire day to us. But I am just going to respect for a few weeks.
Well, I had given my promise way back that I would hear the case, and that I understood that might take at least a day. So yes, we do have a date that we can dedicate to this, sort of foreseeing this coming.
Well, Your Honor, if I can address the court, please.
Well, hold on. I got to get your attorney back.
Okay.
Can we try to contact her? All right, Mr. Williams.
Yes, Your Honor.
General, just sit tight for a second. We're going to get Ms. Woodson back, and then I'll continue the proceeding, okay?
I think with Mrs. Wilson, the attorney Wilson was going to bring to the court attention, because I spoke with her yesterday, and I bring it to her attention that I will be standing pro paper silent.
Okay, Mr. Williams.
Yes.
I'm not going to hear anything until she's present. Okay, here she comes.
All right, Your Honor.
Hello.
Hello, Ms. Woodson.
Sorry.
Okay, there you are.
Yes.
Your Honor.
Okay.
I do want to make, I mean, I know we have a lot of movement. Sometimes dates need to get made. I do have 3 witnesses I got to bring in from out of state. So, we should obviously have a date that's going to work.
Yeah, that's firm. Okay.
Your Honor, I'd appreciate if you'll let Mrs. Wilson bring it to the attention of the court that she is being relieved of as my counsel.
Hang on, Mr. Williams. Will May 1st work?
So.
I don't know. Will that give enough time to get the witnesses here?
I will do my best, Judge, and at the very least, and I don't want to bifurcate it, but if we have to, I can at least get some of the in-state witnesses on and at least get this going on May 1st.
That's right.
I think that's probably our best option because I know the court's so busy. Let's grab that date.
All right, Ms.
And
Woodson,
that works for me as well, Your Honor.
That would? Okay. So that's the date we'll go with. Mr. Williams wants to address the court. Go ahead, Mr. Williams.
Yes, Your Honor. Mrs. Wilson is being relieved as my attorney. That's the first thing I want to bring to the attention of the court. And also I wanted to ask the court that I need to be understood what the court has been holding me for a year. And then I find out here that there is a hearing set for as it stated here, for June the 1st of 2023 to determine whether or not Olisa Susan Williams has been considered as even dead. That's what it states here, but the court has already issued this here case number 23-000104-M.
Mr. Williams, first of all, Mr. Williams, as to that part, I don't know what you're talking about.
Well, they're saying you holding me on behalf of this individual being dead. They're saying they haven't determined as being dead. That's what the hearing is all about.
Mr. Williams, okay, Your Honor, what he's referring to is I believe he was served with a probate matter because mom is finally, now that the charges have been filed, she is pursuing a death certificate in this matter. That's why he's being served with that. This is a homicide case and we are alleging Miss Olisa is very much dead.
Yes.
So
okay, that answers that.
My attention, you understand that, because I asked the court and filed with the court for account, you understand, by a licensed physician, the coroner, to determine what their claim it is. I have nothing, you understand,
Mr. Williams,
there's been a death.
Mr. Williams. Okay, the first thing is, are you intending on representing yourself?
Yes.
Okay.
And I also would like to be brought into the courtroom, you understand, to represent myself and not on.
You will be here.
Thank you. I appreciate that.
You will be able to see me in all splendid color.
Thank you.
That day. Okay, so we got May 1st. That's the date that you'll be here. Right now, Mr. Williams, I'm going to leave Miss Woodson on the case.
Okay. Also, Your Honor, can I get a copy of the motion for discovery I've been asking for a year? I've stated that to the court and I keep being denied a copy of the motion for discovery. Now, the United States Supreme Court justice said that I'm entitled to a copy.
Mr. Williams, Mr. Williams,
yes,
you want discovery. I believe discovery has already been provided to your attorney. Did you ask your attorney regarding that?
The attorney doesn't have a copy. I asked her, she doesn't have it.
Your Honor, I do have discovery and I have given discovery to Mr. Williams. He's talking about a very specific motion that he filed for discovery. I do not have that. I'm not sure when he filed that motion, but in terms of police reports and things like that, he does have that.
That's not a motion for discovery there. That's why you understand I don't need you as my counsel, Mrs. Wilson, because you don't need to know what a motion for discovery is.
Oh, she knows what it is. She found it not.
Would she want to take a comment here on a murder case and don't have a copy of the motion for discovery?
She has discovery.
No, she does not, Your Honor.
She does.
No,
she very much.
It's been turned over.
Report. That's not a motion for discovery.
Okay, look. I am not going to sit here and argue with you, Mr. Williams.
Oh, I didn't realize I was arguing with you, Your Honor. Forgive me, please.
All right. I'm telling you, your attorney has discovery. We went through this before. Additional discovery was provided. It's been made, that representation has been made. There would then be no need for a motion for discovery because it's already been provided. So I'm done dealing with that issue, sir.
Well, then I guess
May 1st.
Go to the next thing. So
thank you, Your Honor.
Well, Your Honor, are you saying then that you have something to provide me that Olisa Susan Williams, by a coroner, a licensed physician, or someone to state that we know there is a death, or have been determined by the court that there is a death, and that you have grounds that can hold me, you understand, regarding, you understand, a charge of death? This is what I need, because from what I've been getting in the courts and what has been presented before me, it does not, you understand, bring to my attention.
Okay, all right.
That's why I
Mr. Williams, Mr. Williams.
The Honorable
Mr. Williams, let me stop you. Let me stop you, Mr. Williams. Come May 1st, or maybe shortly thereafter, the people will be putting on evidence that there has been a death.
Thank you. I'd appreciate
And
it.
so that will happen.
Thank you, because I think that's what we need here to take and try on me on a charge, and death have not been proven. What we got here is accusation.
Well, I think
I've
it
got
will
something
be.
here brought to
We'll
my
have to wait
attention.
till May
Well, let me-
1st.
Can I bring this into your attention, what it was given to me? I was given a copy, and it's dated here for my arrest, and it's dated back here. It says Detective Daniel Everson declared a death in 1982.
Okay.
Now, I've been incarcerated. They told that I don't have true knowledge, but they said I've been
Mr. Williams, Mr. Williams,
95.
Mr. Williams.
Yeah.
Now is not the time. Now is not the time for what you're trying to tell me.
Well, I'm just trying to establish here, and he's had a death this year time.
I understand what you may be trying to establish,
Oh, you do?
but there will
Thank
come
you,
a
Your Honor.
time
appreciate
where
it.
Mr. Williams, Mr.
Your Honor.
Williams, there will come a time I will hear from both sides.
I appreciate that.
And right now, I've set that for May 1st. So you can keep talking at me if you want,
Well,
but
Your
it's
Honor,
not
I'm
going to do
gonna
you any
take
good because I'm just going to
disrespect
tell you I'm going to hear
I
it May
don't wanna do
1st.
that. God
What'd you say?
forbid. I don't want
You
to
are-
disrespect you in any kind of way. God forbid.
Yes, Miss Woodson.
I know the court has kept me on, I guess, as second chair to Mr. Williams. I would advise him to stop discussing the case because things that he says can be used against him.
Okay, I don't need to follow up on that, but you're right. All right.
Also, will you have Mrs. Wilson, will you provide me with everything you have regarding my case after you've been resigned from my case? Any documents that you have, please.
Okay,
provide me
Mr.
with
Mr. Williams, Mr. Williams,
Yes, Your
you
Honor.
had an opportunity to talk to Ms. Woodson. You've got a very good attorney. Ask her for it. And just ask.
Oh, I sure will.
Don't be trying to make all your demands like you're trying to do with me. If you just
Oh.
ask her,
Excuse
she'll
me, Mom.
cooperate with you.
Excuse me,
Okay?
Mom.
All right. I think then we're done for today.
Thank you,
bond
Your
will
Honor. Have a great
Have a
day,
blessed
everyone.
day, and the
Continue.
peace of God be with you and your family. God bless you, and thank you for the.
Or maybe we're not
time.
done. I think the Attorney
Judge,
General
I
may
just
want
have
to
to
say
ask.
something.
I just have to ask, I'm ready to start on May 1st. Does the court have time on May 2nd? I do have an expert witness that is available on the 2nd. If the court's got, if we need to continue, will it be continued on the 2nd, or will we be continuing it on a different?
We would normally give another date. Let me
Okay.
just check. I'm going to give them May 2nd. I'm going to give them May 1st and the 2nd in the morning. And we'll move the Arbor cases maybe to the afternoon, or we'll move them. But we'll give them May 1st and 2nd. We'll just do it that way. Court calls the case, People State of Michigan versus Hector Gonzalez.
Caitlin, on behalf of the people.
Good morning, Your Honor. This is Hector Gonzalez.
And Mr. Mason?
If it pleases the court, Judge, and I'm not sure what the court's will and pleasure is. We filed and served our motion to quash and request a Walker hearing on February 15th. We did serve that on the prosecutor's office, and then pursuant to Ms. Kirby's instructions, on February 16th, I reached out to her supervisors. And as of this morning, I don't know what happened. Miss Kirby did not get a copy of our motion, so our office resent the original email. I did not hear back from her supervisors. I'm not blaming that on Miss Kirby. I don't know if it's the courts, what the protocol is, if the court wants to hear the motion at the district court level, or if we should waive it up to circuit court and the circuit court judge would hear the motion. Because I think that's, kind of the issue we're down to, and I'm not sure what the protocol is down there. Or what Miss Kirby's will and
Ms.
pleasure is.
Kirby?
Yes.
What would be your pleasure on that? I mean,
Um,
I'd hear it, but I think typically they're heard at the circuit court level, but
Yes, and I did tell Mr. Mason that typically the Walker hearings are heard at the circuit court level. I also did send an email, he probably didn't get it, that if the court is going to hear it and wants to hear it, that I would ask for a special date. I think we have another evidentiary hearing set for April 5th in the afternoon. So if that's what the court would like to do, I would ask for that special hearing date if that works for Mr. Mason. And then as far as Ms. Reiser, the email that Mr. Mason sent Ms. Reiser, I believe they did have a prior conversation on the phone before that email about working out a deal for his client. And that is not something, as far as that deal goes, that's something the police agency works on and then brings it to our office if that's something that they want the defendant to participate in. So that's not really something Mr. Mason would have to work that out with Corporal Webb.
Yeah, I would just indicate for the record that the conversation with Ms. Reiser was 2 years ago, and Corporal Webb indicated that we would have to get Ms. Reiser's permission to do it, or at that time it was Conrad Seiler's. Then Conrad Seiler left and we got Ms. Reiser. So I've sort of been a ping pong ball because the prosecutor's office says you have to work with the corporal and the corporal says he can't do anything unless the prosecutor gives you permission. So I can only do what I can do. If someone stands up and says, I will take authority over this and I will own it, we will gladly work with that person. And if the protocol is that these motions,
I don't even know what that meant, Mr. Mason. You just deal with the prosecutor's office. You guys, I mean, if you're talking about something that happened 2 years ago, that would have been a switch in the prosecutor's office. It's not anybody's fault as to who you might have to talk to. So maybe you ought to take that down a level and try to deal with it. I'll set the Walker hearing. You'll hear it before me. I'll just set it on the 5th. Let's get it done.
hold on a second. If it pleases the court, let me look at my schedule because my inclination was to waive the matter up.
Okay, then if that's what you want to do, just waive it and you can raise it there.
Yeah, I just wanted to make sure it was preserved and I wanted it to get into the prosecutor's hands as soon as possible.
I got a copy of it in the file. Are we waiving?
Yeah, we'll do a waiver, Your Honor.
All right, Mr. Gonzalez, you've heard your attorney has indicated that you're waiving your right to a preliminary examination.
That's correct.
Okay, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed or that the offense alleged was committed and that you committed it.
Correct, Your Honor.
All right, and you understand that you won't have that proceeding and you'll proceed to circuit court to resolve this matter. You understand that, sir?
Yes, Your Honor.
Court calls the case of the people versus Shabab Jackson.
We're ready in that matter, Your Honor.
Laura Willenbring for the people.
Mr. Jackson, could you state your name for the record, please?
Shihab Jackson.
Your Honor, today is the date and time set for the probable cause conference. My client respectfully requested this matter be set for preliminary examination at the earliest possible date.
April 4th, 2023, 9 a.m. before me.
What happens before now and then with concerning bond?
You're out on bond now, Mr. Jackson. Is there some aspect that you want to have addressed?
Yeah, I have to. Well, it's Ramadan right now, and I have religious obligations as well as work obligations in general. And for some reason, it wasn't a drug case or have anything related with drugs. And I'm on what do you call it? The daily reporting thing. And I believe I may have. I think I missed mine yesterday. I don't mean to be in violation, but I'm just sort of struggling with that and confused as to why that is.
Your Honor,
if there's a way to lessen that, or like, I don't see the reason for being on for drug testing.
Your Honor, having heard what Mr. Jackson has stated, we'd ask that the tether aspect or the drug testing aspect actually be reduced in this case or dismissed in this case. As he stated, there is no drug aspect to this case whatsoever. And this just serves as an added burden on him.
He's on intermediate supervision.
I'm not sure
As
why,
set
Your
by
Honor.
the-
That was,
I'll handle it, Mr. Jackson. I got you.
as set by the magistrate back in the beginning of March. I'm disinclined to change that at this point. I guess I'm not sure why his testing, why Ramadan would interfere with his testing. I understand that he may have certain obligations, but I have other individuals who are engaged in the celebration of Ramadan who aren't having these issues.
well, it's not
So-
celebratory, sir. I just fail to see the connection with the nature of my case and having to go out of my way and pay money that I really don't have and time that I don't have to drug test on this matter, especially
That's not
considering that
that's not a basis for me to change it. I thought that what he was indicating, because he had started out that it was Ramadan, and I thought that there was some interference with what he had to do, but I'm not changing it. I'm going to leave his bond as continued. We can see him on the 4th.
Thank you, Adam.
Your Honor,
Thank
may I
you.
address two matters briefly?
Is it?
Yes.
Hold on, Mr. Jackson.
Your Honor, I believe his name was spelled incorrectly on the complaint. I understand it's properly spelled SHIHAB. It was
So
spelled with an
no
extra B.
no first B.
That's correct, Your Honor. And his date of birth was incorrect on the original charging documents.
So is it not possible to amend the drug testing, Your Honor? I understand is it just a?
Okay, so hold on.
Yes,
Hold
sir.
on. I think I already said that. And I wasn't going to say anything. I will make, Ms. Willenbury, I'll make all the changes that you want. I'm just going to tell you something, sir.
Yes, sir.
What I will do what I can for people. I am also very for those that work around me. I got a message that you were very insulting to my clerks. So you ought to be that I'm
Mr.
letting
Jackson,
you
stop talking.
I can't hear. I'm just seeking clarity, sir.
Mr. Jackson, stop talking.
I'm not talking, sir.
So
Okay.
see, it's that attitude that's the problem. So what
Sir,
I'm going
I'm
to
a
do
young black
is I
man
will.
fighting for his life. I'm listening.
You need to be quiet.
I am. Sir,
Mr. Jackson, let the judge talk.
I understand. I'm not sure if there was a mute or something. I'm just making sure. I understand.
Okay, so you don't have to respond to everything that's said. You don't have to get the last word. That's not a good.
I'm not trying to. My life is on
Okay,
the line here.
all
That's
right.
all. That's all I'm.
Okay, you know what? You know what? Put some deputies at that door right now, right down there at the door. Because he apparently just called security, get him down at that door. Because apparently he doesn't want to listen to his attorney. He doesn't want to listen to me.
Sir, I'm just seeking clarity on the matter. That is all. I promise. I'm a black man in the system, just trying to fight for his freedom. That's all.
Okay, so am I. So
You're
don't
not
even
fighting
try
for your
it.
freedom,
Don't
sir. With all
even
due
try
respect.
it. Don't even try it.
Don't even try
Alan,
what,
get
sir?
down there.
Tyree
Get
Lee
down
was
there.
supporting
Get
black
down there,
officers
Alan.
beat black
Just
people.
get
to
down
death,
there.
sir.
Take him in.
I'm
going to find you in contempt for interrupting the court.
I'm not trying
Mr.
to-
Brown, if you've got somebody down here,
Sure,
he
I'm
can
just
come in
seeking-
and he can see me in person. We'll wait for a prosecutor to get down here and I'll deal with this in person. I'm passing it right now, but right now he's being taken in because I'm not dealing with
What
him.
about,
I'll
sir?
pass this matter.
Sir,
Mr. Jackson, if you will just maintain your.
Court does call the case of the people of the state of Michigan versus Jessica Lynn Kyle.
Mr. Ganatra, first Assistant Prosecuting Attorney on behalf of the people.
Zachary Ward on behalf of Ms. Keel, Your Honor. Can we approach very briefly on this matter?
You really want to go into a room with me
Your
right
Honor,
now?
Your Honor,
Sure,
I don't
fine.
think.
Yeah,
Your
give
Honor-
us a bench conference.
Your Honor.
Put Mr. Ganatra and Mr. Ward into a room with me. Mr. Brown, is somebody coming down to talk to your client, or do we need to send him down and then bring him back up later?
I've been in contact with Ms. Gaines. I know she's there now, and she said she would be happy to speak to him for me. So thank you.
Okay. All right. So if we can let Ms. Gaines know, I think she's over in that office, and then they can see him up here if that will work. Okay.
Thank you,
Yes.
Ms. Gaines. And for the record, Ms. Gaines is also still a public defender.
That's where her heart is. She will always be a public defender. I'm not worried about anybody else but Feaster right now. Because something, I don't know what happened. I'm just okay.
We'll get it right.
I just have to say this. The other thing that's funny about that is yesterday we had a prosecutor give her appearance, and she gave her appearance as a public defender.
Oh, there you go. There you go.
So it all evened out. It just didn't know that it was coming from Feaster.
I heard somebody talking about a prisoner exchange. I don't know what that means.
that might be what's going on. Okay. Court calls the case of the people versus Barrage Scott. 2 cases.
Nemish Ganatra, first assistant prosecuting attorney for the people.
Sandra White on behalf of Barrage Scott, I believe it's 22 FB 1390.
And Andrew Meyer on behalf of Barrage Scott in matter 23 F20217. Mr. Scott, I think you're on the phone. Could you unmute and say?
Yeah, I'm on the phone. I'm already unmuted. Hello?
All right, Barrage, state your name.
Yes, sir. Barrage Scott, Judge Simpson.
All right, thank you. Okay, what are we doing on these cases?
Your Honor, I was going to ask for an adjournment. I did email with Mr. Ganatra. Mr. Scott did his assessment for mental health court on Tuesday. He does believe he was accepted because he was told to report next Wednesday, but we haven't received a report.
Okay.
And Your Honor, rejoining that request for the same reasons, but I think there also may be potentially more charges coming too. So maybe a 3-week adjournment may make sense here.
Marcel Jones. Is the times all the same?
Okay. All right. What I'll do is I'll adjourn this out, both of these matters out to the 13th, April 13th, 2023, 9 a.m. for Zoom in.
Let me, we'll still take a minute. Okay, so you grapple.
Mr. Scott?
Yes, sir.
Are you trying to say something, or is that this background noise where you are?
Background noise. I wasn't trying to say anything yet, but if you want like me to say something, I would like to give you words of wisdom that I learned today.
You want to get my words of wisdom?
Yeah.
They ran out at 10 o'clock. Okay.
Oh,
what now? What's going on, Barrage?
Nothing. I just started school yesterday, and I'm supposed to be working sometime next week. And I just been, trying to get back into working and reading. I worked on my reading yesterday. It was my first day of going to school, and I'm doing the literacy program. And I go to the library over there by the green, and I just been staying out of trouble, trying to stay out of trouble and do what you told me. I'm very happy that mental health court is accepting me, because the dude that I talked to, he gave me some paperwork, and then he said I have to be there Wednesday to see Judge Valvo at 1:30, but I don't know if y'all got that. He said he would have to email y'all that stuff, and I don't know I don't have no email, so I can't do it.
Okay, so here's what you need to do.
Okay.
That information should get emailed, hopefully, to Mr. Meyer or Ms. White. They'll double check with the court. And then the important thing for you is to keep in contact with them so that they'll be able to tell you what you need to do come Wednesday, okay?
Yes, sir.
All right.
Thank you.
And Barrage,
Yes,
we've
sir.
had our differences.
Yes, sir.
I'm glad that you're in
I'm sure. I'm glad too. It's a good thing. I was working on my reading yesterday. I didn't know I could read that well.
Okay. You start doing that, life will get a whole lot better, okay?
Okay.
All right, Barrage, you take care. His bond will
And
continue
can you
on these
tell me?
matters.
Can you tell me what date I had to come to court again? 13th at 9 o'clock, right?
Yes.
Okay.
13th.
Thank you.
Thank
Okay.
you.
Thank you. Am I done?
You're done.
Okay.
Thank you, Your Honor.
For today. Court call. I guess I shouldn't have said. Court just called the case. People say to Michigan versus Ahmad Tomlin.
Nimish Ganatra, First Assistant Prosecuting Attorney for the People.
And Andrew Meyer on behalf of Hamad Tomlin. Mr. Tomlin, could you please unmute and state your name?
Wrong button.
Thank you.
There.
Thank you. How you doing, Mr. Simpson?
I'm doing well, Hamad. How are you?
As you can see.
Yeah, I don't know. I don't like that. All
I
right.
know, but
No, but that,
I'm still living.
okay.
So.
That I don't know about that beard either, but we'll deal with that later. I won't get on you about it today. Trying to act like you all grown up. All right.
Yeah, man, I'm trying. How you been though?
I've been well, and I hope you have too, other than maybe this little hiccup.
Right.
Okay. What are we doing on this case?
Your Honor, this is the time and date set for a probable cause conference. I've had some conversations with Mr. Tomlin, but he wants some additional time to consider his options and for me to continue conversations with the prosecution. So we are asking for a 2-week adjournment here.
Probable cause conference, April 6, 2023. 9 a.m. or as your Zoom invite indicates, his bond will continue. You know,
Thank
Mr.
Mr.
Tomlin,
Simpson.
a number of years ago, you told me you weren't going to come back. I wasn't going to see you
Man,
again.
listen,
I know. I remember
you're right.
everything. Just
You're
telling
right.
you.
Oh, I know. Listen, I was just telling my wife. I said, "Listen, I've had a long history with him. He don't like baby blue. You know what I'm saying? I know. I already know.
What I don't like. Not that I don't like baby blue.
I know
It's
that. I know
that
the team. Look, I ain't gonna say the team.
I am a Maryland Terrapin, and so when they were in the ACC and people would show up in North Carolina blue, it would drive me crazy. I'm glad you.
I remember. Listen, I remember everything you've ever said to me. I remember.
All right, my friend. Take care.
Yep.
We'll see you in a couple weeks.
You too.
All right. You remembered all that. Court calls the case. People versus Tristan. Is it Wathen? They are not checked in.
I talked to him yesterday. I was
Okay.
going to get Miss Lundy some information so that we could try to resolve the case, but we need.
Chairman, we
You can still
approach
give it
very
to her.
briefly.
You want to approach? Yes. All
I
right.
do.
Thank you. All right. Record should reflect we've had a bench conference in this case, and the defendant's not here. The court is going to issue a bench warrant for defendant's failure to appear.
Your Honor.
Bond. Yes. Hello.
Public Defender Kelly Yankee. I was actually just on the phone with him. He was having technical difficulties. He should be logging in right now.
Walking in.
Good
Logging in.
Oh, he should be logging in right now.
Yes, Your Honor. He was having difficulties with the Zoom link. He informed
See,
me.
that's the problem with Yankee. She doesn't show up all day, and then all of a sudden, huh? I know, but I ain't heard from her all day. And then all of a sudden, she pops in to mess up my bench warrant.
She's been advocating for Mr. Feaster's employment status.
Okay, well, I'll peel off the sticker and
Oh, wow.
we'll wait.
Okay, thank you very much.
If he doesn't show up, I'm holding you personally responsible.
Understood, Your Honor.
That means you get the warrant.
Okay.
See,
right.
no, and that's funny because Ron Brown didn't even step in to like protect you or anything. He just said, okay. All right, we'll wait for him.
Thank you, Your Honor.
Then let's go back to the individual Ms. Yankee saved. People calls the case of the People of the state of Michigan versus Tristan Wathen.
Ashley Lundy for the people.
Ron Brown appearing on behalf of Mr. Watt.
He is here now. He did sign in. Okay. What are we doing on this?
I'm requesting a bench warrant. I mean, I'm requesting a adjournment. An adjournment, Your Honor. Recall the bench warrant. Recall.
This whole day has sort of been the upside down day. I don't know. You are taking like lessons from Feaster and asking for anyway. Let me adjourn this out. Probable cause conference all adjourned to April 13th, 2023. 9 a.m. or as your Zoom invite indicates. And Mr. Wathen, you now understand how to get yourself on, right? Okay. Bond continued. Thank you.
Oh, yeah. Sorry, I was muted. I do understand how to sign
yeah,
it.
it's okay. I just want to make sure. Okay. So hold that lesson at least until the 13th. Thank you, sir.
Yes, sir. Thank you.
The only case I have left is my friend in back. All right. And I think Ms. Willingbrink is here and Joy Gaines is actually here. So if we could get Miss Gaines to come into the courtroom, we can bring what's his name out. Okay. Give us a minute. We'll have him brought out, folks. Thank you. Court recalls the case of the people versus Shahab Jackson. Counsel, state your appearances.
Laura Willenbrink for the people.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Jackson. Mr. Jackson, would you state your name for the record, please?
Jackson.
All right. We're here. I set this already for preliminary examination, and it didn't seem to me, quite honestly, that the defendant was being cooperative with anything, and I didn't know what his problem was. And so I was considering revoking his bond and having him sit. But I would like to give him an opportunity or have counsel explain to me what's going on with this young man, because the behavior was unacceptable.
Your Honor, I've had an opportunity to talk to Mr. Jackson, and I want to start with that. We did talk about, and I was able to explain to him what contempt is considered in court. We went over that the definition is a willful act, omission, or statement that tends to impair the authority or impede the functioning of the court. In the course of our conversation, I learned that in 2015, so approximately 7 years ago, during Ramadan, Mr. Jackson was incarcerated and his grandmother died, and he was unable to get a pass, go to the services, spend any last few days with her. And so this time frame specifically is very triggering, but definitely with him being involved in court again. He has indicated that he would allow me to do the talking today to demonstrate just what he's doing right now. And so with that, we are asking that Your Honor give him another opportunity to come into court on his own.
Is there anything from the people?
Your Honor, just two things briefly. I was in the process of amending his name and birth date. I did send an amended complaint over to the court.
We have received that. Go ahead.
I also wanted to mention that the defendant has come to our office a few times and did drop off some materials, including a flash drive. Defense has been notified of that. And he has also tried to be connected with either myself or another APA in our office, but has been told that we cannot communicate with him because he is represented. So I just want to make sure that he understands that neither myself or another APA will be talking to him directly because he is represented by the public defender's office.
All right. Thank you. I realized he wasn't going to say anything, but Yeah, please.
So in our discussions, Mr. Jackson and I, we did talk about the fact that our office is representing him. Specifically at this time, I am the attorney, and that is part of my job, is to participate in the court proceedings. So, yes.
Well, and I'm going to tell you from my standpoint, he kept trying to overtalk me, and that ultimately, and you can tell him, Ms. Gaines, anybody that's been before me, that will never happen. And then, but what was so bad is the person that's trying to help you, Mr. Brown, is trying to get you to be quiet, and you kept talking. And I don't know where you thought you were going to get to, but I can tell you right now, you do that in my court, this is where it leads. I can't tell you necessarily that you're going to listen to your attorney, but you're certainly not going to sit up there and interrupt them. And I'll tell you, I've been doing this for a long time. And when I see somebody that's not listening to their attorney, especially somebody that's esteemed as Mr. Brown, and others telling you what to do, that's a person that's not going to listen to anything. I have to almost believe they're not going to listen to anything I'm telling them to do. Those are the people that end up getting themselves incarcerated. I'm then also very disturbed that you've got defense counsel, and then you're down at the prosecutor's office. I don't even know why you're down there. Well, you're trying to give them something or whatever, and you're trying to give them something. You haven't told your attorneys that what you're doing. That doesn't even make any sense. It's almost like you want to get locked up. I will be honest with you, sir. I looked at the charges and see your previous record. I get what may have happened to you in 2015. I see the timing of it when I'm looking at your record, but then I see what you did afterwards. Whatever your thoughts are, you just got to do better. There is no reason coming in here today that this should even be occurring. Tell you what, I'm going to trust Miss Gaines. Miss Gaines tells me that I should give you another chance, and Mr. Brown told me the same thing, that I should give you another chance. These are these people you won't listen to, by the way. But if they tell me to give you another chance, I'll give you another chance. But I'm going to let you know you don't have any other opportunity with me to mess up. You mess up, I'm sending you. Am I understood?
That a yes?
I'm also going to add so I will continue his bond. He can be released to custody. I have the amended complaint. I am going to also add as a condition of his bond to be entered into lien that you are not to go within 500 feet, except if you're going to, well, that's outside of the 500 feet of the Washtenaw County Prosecutor's Office in downtown Ann Arbor. You understand that?
He's indicated yes, sir.
Pardon?
He's indicated yes, sir.
All right, very good. So we're adding that to lien. So I want you to know what that means. If you're within 500 feet of their offices, police officers come on you. They can arrest you on that. So don't say you didn't understand because I explained it to you. Anything further?
No, thank you.
All right, his bond can continue. He can be released. Thank you, Ms. Willenbrink, for waiting around.
Thank you, Your Honor.
14A stands adjourned.